Chapter 2: Ideology and Law. The question of the ideological nature of law played an important part in the polemic between Stutzke and Reisner. Professor Reisner tried to establish that Marx and Engels themselves considered law as one of the, quote, ideological forms, end quote, and that many other Marxist theoreticians held the same view, supporting his argument with an impressive number of quotes. One cannot quibble with these references and quotations, just as one cannot question the fact that people experience law as at a psychological level, especially when it figures as general norms or regulations of principle. However, it is not a matter of affirming or denying the existence of ideology or psychology of law, but rather of demonstrating that the categories of law have absolutely no significance other than an ideological one. Only if this were established could we accept as incontrovertible Professor Reisner's conclusion, namely that, quote, a Marxist can study law only as a subcategory of the species of ideology, end quote. The little word only is the crux of the matter. We shall illustrate this with an example from political economy. The categories commodity value and exchange value are indubitably ideological constructs, distorted, mystified mental images, as Marx put it, by means of which the society based on the exchange of commodities conceives of the labor relation between individual producers. The ideological nature of these forms is proven by the fact that no sooner do we come to other forms of production than the convergence of the commodity value and so on cease to have any validity whatever. Consequently, we are justified in speaking of a commodity-oriented ideology, or as Marx called it, quote, commodity fetishism, unquote. And in classing this phenomenon as a psychological one. Nevertheless, this in no way implies that the categories of political economy have an exclusively psychological significance, or that they relate solely to experiences, representations, and other subjective processes. We are well aware that the category, quote, commodity, for instance, its blatantly ideological character notwithstanding, reflects an objective social relation. We also know that the various stages of development of this relation's greater or lesser degree of universality, are material facts which must be taken into account as such, and not merely as ideological psychological processes. It follows then that the general concepts of political economy are not merely ideological factors. Rather, they are abstractions of a kind which enables objective economic reality to be scientifically, that is, theoretically, constructed. To quote Marx, quote, they are forms of thought which are socially valid, and therefore objective, for the relations of production belonging to this historically determined mode of social production, i.e., commodity production, end quote. What we need to establish, therefore, is not whether general juridical concepts can be incorporated into ideological processes and ideological systems. There is no argument about this. But whether or not social reality, which is to a certain extent mystified and veiled, can be discovered by means of these concepts. In other words, we must be clear about whether or not the categories of law are objective forms of thought, objective for the historically given society, corresponding to the objective social relations. Hence we formulate the question as follows. Can law be conceived of as a social relation in the same sense in which Marx called capital a social relation? Can law be conceived as a social relation in the same sense in which Marx called capital a social relation? Putting the question in this way immediately makes any reference to the ideological nature of law unnecessary and transposes the whole analysis onto a different plane. Having established the ideological character of particular concepts, in no way exempts us from the obligation of seeking their objective reality. In other words, the reality which exists in the outside world, that is, external and not merely subjective reality. Otherwise, any distinction between life after death, which does exist in some people's minds, and let us say the state, would be obliterated. Yet this is exactly where Reisner's approach leads. Reisner bases himself on the well-known Engels quotation about the state as the, quote, first ideological power over man, end quote, and has no hesitation in equating the state with its ideology. Quote, the psychological nature of manifestation of power is so obvious, and even state power, which only exists in the human psyche, is so lacking in material characteristics that one would think no one could see state power as anything but an idea, which only materializes in real terms, to the extent that people make it the principle governing their behavior. End quote. Reisner. The treasury, the military, the administration, all these supposedly lack material characteristics. All this only exists, quote, in the human psyche, end quote. Yet what is supposed to become of that mass of the population, the, quote, colossal, end quote, in Reisner's own words, which lives, quote, beyond consciousness of the state, end quote. Obviously, this mass will have to be excluded. Indeed, it seems to have no bearing whatever on the, quote, real existence of the state. However, then, do matters stand with the state as an economic entity? Or is the tariff barrier an ideological and psychological process as well? One could raise a great many questions of this kind, yet they would all come to the same thing. The state is not merely an ideological form, but is at the same time a form of social being. The ideological nature of the concept does not obliterate the reality and the material nature of the relations which it expresses. It is understandable that Kelsen, the consistent neo-Kantian, should maintain the normative, the purely speculative objectivity of the state, and that he should jettison not only concrete material factors, but even the actual human psyche as well. There is no way we can comprehend a Marxist, materialist theory which tries to operate on the basis of subjective experiences alone. Moreover, Reisner, his latest work shows him to be an advocate of Trzynski's psychological theory, a theory which completely, quote, carves up, end quote, the state into a set of imperative attributive emotions, would not be averse to linking this viewpoint with Kelsen's neo-Kantian formal logical conception. At all levels, such an attempt does credit to the versatility of our author, even if it be undertaken at the expense of methodological consistency and clarity. One thing or the other, either the state is an ideological process, Trzynski, or, as Kelsen maintains, the state is a regulative idea, having absolutely nothing to do with any processes which occur in time and are subject to the law of causality. In trying to combine these two positions, Reisner lapses into a completely undialectical contradiction. The formal completeness of the concepts of state territory, population, state authority reflects not only a particular ideology, but also the objective fact of the formation of a tightly centered real sphere of dominance, and thus reflects, above all, the creation of an actual administrative, fiscal, and military organization with the corresponding material and human apparatus. The state is nothing without means of communication, without the possibility of transmitting orders and decrees, mobilizing the armed forces, and so on. Does Reisner think that Roman army roads or modern means of communication can be numbered among the phenomenon of the human psyche? Or does Reisner think that these material elements simply need not be taken into account as factors affecting the formation of the state? If so, we should indeed be equating the reality of the state with the reality of, quote, literature, philosophy, and other products of the intellect, end quote. What a pity that the practice of the political power struggle radically contradicts this psychological view of the state, confronting us at every step with objective material factors. This leads us to the observation that the inevitable outcome of the psychological standpoint adopted by Reisner is hopeless subjectivism which leads nowhere. Quote, state power as the creature of as many psychologies as there are individuals. State power which manifests as many different models as there are diverse groups and class-based environments will naturally assume a completely different shape in the consciousness and behavior of a minister and that of a peasant as yet unfamiliar with the idea of the state, in the psyche of a statesman and that of a convinced anarchist. In a word, people's conception of the state varies in accordance with their social status, their trade, and their level of education. End quote. Reisner. It is abundantly clear from this that to remain on the psychological plane is to forfeit all grounds for speaking of the state as an objective entity. Only by regarding the state as a real organization of class rule, taking all its aspects into account, not the psychological alone, but also and above all the material aspects, does one acquire a firm basis for studying the state as the state really is, rather than merely the countless and varied subjective forms through which the state is reflected and experienced. Given that these abstract definitions of the legal form not only imply certain psychological or ideological processes, but are concepts which express objective social relations, in what sense can it be said that the law regulates social relations? Surely we do not wish to imply that social relations are self-regulating. For if we say that this or that social relation takes on legal form, this is not meant to be a mere tautology. Law assumes legal form. At first sight, this objection seems very convincing and appears to leave no alternative but to acknowledge that law is ideology. Nonetheless, we shall endeavor to find a way out of these difficulties. So as to make this task easier, we shall take refuge yet again in a comparison. As we know, Marxist political economy holds that capital is a social relation. As Marx says, capital as a social relation cannot be discovered by means of a microscope, nor is it exhaustively dealt with in experiences, ideologies, and other subjective processes occurring in the human psyche. It is an objective social relation. Further, when we observe, let us say, in petty commodity production, a gradual transition from labor for a customer to labor for an entrepreneur, we conclude that the corresponding relations have assumed capitalist form. Does this mean that we have lapsed into a tautology? Not at all. In saying this, we have simply stated that the social relation known as capital has tinted or transferred its own form to a different social relation. We are able to establish this by considering all the processes involved, purely from the objective side, as material processes, eliminating completely the psychology or ideology of the participants. Is there any reason why the situation should not be just the same with regard to law? As it is a social relation in itself, law is capable of coloring other social relations to a greater or lesser degree, or of transmitting its form to them. However, we can never gain access to the problem from this angle if we allow ourselves to be guided by an unclear notion of law as, quote, form as such, end quote. Just as vulgar political economy was not able to grasp the nature of capitalist relations, because political economy started from the concept of capital as, quote, accumulated labor in general. Consequently, we escape the apparent contradiction if we succeed in establishing, by analyzing its fundamental definitions, the law represents the mystified form of a specific social relation. It would not then be far-fetched to assert that in certain cases this relation transmits its own form to some other social relation, or even to the totality of social relations. The same applies to the second apparent tautology, according to which law regulates social relations. If one strips this formula of a certain anthropomorphism attached to it, it reduces itself to the following. Under certain conditions, the regulation of social relations assumes a legal character. This is undoubtedly a more correct way of putting it, and most importantly, it is historically more accurate. There is no denying that there is a collective life among animals too, which is also regulated in one way or another. But it would not occur to us to assert that the relations of bees or ants are regulated by law. Turning to primitive peoples, we do see the seeds of law in them, but the greater part of their relations are regulated extra-legally, by religious observances, for instance. Finally, even in bourgeois society, there are things like the organization of the postal and rail services, of the military and so on, which cannot be related in their entirety to the sphere of legal relations unless one views them very superficially and allows oneself to be confused by the outward form of laws, statutes, and decrees. Train timetables regulate rail traffic in quite a different sense than, let us say, the law concerning the liability of the railways regulates its relations with consignors of freight. The first type of regulation is predominantly technical, the second primarily legal. The same distinction exists between a plan for mobilization and the law covering universal conscription, between a brief for investigating crime and criminal proceedings. We will come back to the difference between technical and legal norms in what follows. For the moment, we merely make the observation that the regulation of social relations can assume legal character to a greater or lesser extent. For the moment, we can merely make the observation that the regulation of social relations can assume legal character to a greater or lesser extent, can allow itself to be more or less colored by the fundamental relation specific to law. Only when observed in a superficial or merely formal manner does the regulation of standardization of social relations appear fact. There are striking differences. Only when observed in a superficial or merely formal manner does the regulation or standardization of social relations appear fact. There are very striking differences in this respect between as a fundamentally homogeneous and purely legal process. In the various spheres of human relations, Gombolowicz first drew a sharp dividing line between private law and state norms, but in so doing he tried to admit of only the former sphere as the undisputed domain of jurisprudence. In reality, the hardest core of legal haziness, if one may be permitted to use such an expression, is to be found precisely in the sphere of civil law. It is here, above all, that the legal subject, the persona, finds entirely adequate embodiment in the real person of the subject operating egoistically, the owner, the bearer of private interests. Juridical thought moves most freely and confidently of all in the realm of private law. Its constructs assume perfect and well-ordered forms. Here the classical shades of Aulus Aegirius and Numerius Negedius, those Roman protagonists of procedural questions, who are the inspiration of the jurist, hover over him constantly. It is above all in private law that the a priori principles and premises of juridical thought become clothed in flesh and blood of two litigating parties who, vindicta in hand, claim their, quote, right, end quote. Here the role of the jurist as theoretician merges with his practical social function. The direction of private law is no more than an endless chain of deliberations, for and against hypothetical claims and potential suits. Behind every paragraph of the systematic thread of the argument stands the invisible abstract client, ready to utilize the theses in question as legal advice. The learned disputes between academic jurists about the significance of error or about the allocation of the onus of proof are no different from similar disputes before the courts. The distinction here is no greater than that which used to exist between knightly tournaments and feudal battles. Knightly tournaments took place, as we know, with great bitterness, at times claiming no lesser expenditure of energy, no fewer victims than real affrays. Only when the individualistic economic system has been superseded by planned social production and distribution, will this unproductive expenditure of man's intellectual energies cease. A basic prerequisite for legal regulation is therefore the conflict of private interests. The conflict of private interests is both the logical premise of the legal form and the actual origin of the development of the legal superstructure. Human conduct can be regulated by the most complex regulations, but the juridical factor in this regulation arises at the point when differentiation and opposition of interests begin. Gumplowitz states that, quote, controversy is the fundamental element of everything juridical, end quote. In contrast to this, the prerequisite for technical regulation is unity of purpose. For this reason, the legal norms governing the railways, liability, are predicated on private claims, private differentiated interests, while the technical norms of rail traffic presuppose the common aim of, say, maximum efficiency of the enterprise. To take another example, healing a sick person presupposes a set of rules, for the patient as well as for the medical personnel. Insofar as these rules have been prescribed for the express purpose of rehabilitating the sick person, they are technical in nature. The enforcement of these rules can be associated with some degree of constraint on the sick person. So long as this constraint is viewed from the standpoint of a goal, which is the same for the person exercising the coercion as it is for the person coerced, it is a technically expedient act and no more. The content of the regulations is specified within these limits by medical science and undergoes change as medical science progresses. The lawyer has no place here. His role begins at the point where we are forced to leave this realm of unity of purpose and to take up another standpoint, that of mutually opposed separate subjects, each of whom represent his own private interests. Doctor and patient are thereby transformed into subjects with rights and duties, and the regulations which govern them are transformed into legal forms. Simultaneously with this, coercion is no longer considered under the rubric of expediency, but from the point of view of formal, that is, of legal admissibility. It is not hard to see that the possibility of taking up a legal standpoint is linked with the fact that, under commodity production, the most diverse relations approximate the prototype commercial relation and hence assume legal form. Similarly, it is a matter of course for bourgeois jurists to infer the universality of the legal form. either from eternal and absolute characteristics of human nature, or from the fact that official decrees can be arbitrarily applied to any subject. It is hardly necessary to give detailed evidence of the latter. In the civil code of the pre-revolutionary Russian Empire, there was, after all, an article imposing on the husband the duty to, quote, love his wife as he loves his own body, end quote. Yet even the most presumptuous jurist would hardly have attempted to construe a legal relation, allowing for the possibility of suits on this basis. On the contrary, no matter how ingeniously devised and unreal any one of the juridical constructs may appear, it is on firm ground as long as it remains within the bounds of private law, and of property law in particular. It would otherwise be impossible to grasp the fact that the fundamental trains of thought of Roman jurists have retained their significance up to the present day, and have remained the ratio scripta of every commodity-producing society. In the above, we have, to a certain extent, anticipated the answer to the question raised at the outset, as to whether a social relation, sui generis, is to be found whose inevitable reflex is the legal form. In what follows, we shall try to establish that this relation is the interrelationship of the owners of commodities. The usual analysis to be found in absolutely any philosophy of law construes the legal relation as a relation par excellence, as a relation of human wills in general. This view starts out from the, quote, end results of the developmental process, end quote, from, quote, current modes of thought, end quote, without accounting for their historical origin. Whereas in reality, as commodity production develops, the natural prerequisites for the act of exchange become the natural premises or natural forms of all social intercourse. Acts of trade are seen by the philosophers, in contrast to this, merely as particular examples of the general form which in their minds has assumed an eternal quality. Comrade Stucke has quite rightly posed the problem of law as a problem of social relations. Yet instead of setting out in search of the objective social reality specific to this relation, Comrade Stucke turns back to the usual formal definition, albeit qualified by class determinants. In Stucke's general formulation, law no longer figures as a specific social relation, but as the sum of relations in general, as a system of relations corresponding to the interests of the ruling class and to the safeguarding of those interests by organized violence. It follows, therefore, that, within this class framework, law as a relation is indistinguishable from social relations in general, and Stucke is no longer in a position to parry Professor Reisner's malicious question as to how social relations were transformed into legal institutions, or, for that matter, how law transformed itself into itself. Perhaps because it emanated from the womb of the People's Commissariat for Justice, Stucke's definition is adapted to the needs of the practicing lawyer. It illustrates the empirical limit which history imposes on juridical logic, but does not expose the deep roots of this logic itself. His definition uncovers the class content concealed within legal forms, but does not explain why this content assumes that particular form. For bourgeois philosophy, which regards the legal relation as the eternal natural form of every human relation, this question never even arises. For Marxist theory, which strives to penetrate the secrets of social forms and to reduce all social relations to man himself, this task must take priority.